My name is Belinda Bennett. I'm the Head of School and Dean for the School of Law and Justice here at the University of Newcastle. I'd like to begin by acknowledging the Awabakal and Worimi people as the traditional owners of the lands where we're meeting today, and pay my respects to elders past, present and emerging. And I'd like to acknowledge any Aboriginal and Torres Strait Islander peoples who are here with us today. I'd like to welcome everybody today who's joined us for this very special event. Vice-Chancellor Professor Alex Zelinsky, Pro-Vice-Chancellor of the College of Human and Social Futures, Professor Robert Greenberg, colleagues and students, welcome. Just a housekeeping announcement before I introduce our guests today. In the unlikely event of an emergency, please follow the evacuation signs. You'll see one here over to my right, to your left, and please follow any of the emergency orders and their instructions. So to introduce our guests today, in today's event, we'll have an opportunity to learn more about what it's like to work in the High Court of Australia. And we're honoured and delighted to have with us today the Honourable Michael Kirby, AC CMG. Michael Kirby, yes? Michael Kirby is an international jurist, an educator and a former judge. And amongst his many roles, he was chairman of the Australian Law Reform Commission from 1975 to 1984, a judge of the Federal Court of Australia from 1983 to 1984, president of the New South Wales Court of Appeal from 1984 to 1996, president of the Court of Appeal of the Solomon Islands from 1995 to 1996, and justice of the High Court of Australia from 1996 to 2009. He's also undertaken many international activities for the United Nations, the Commonwealth Secretariat, the OECD, and the Global Fund Against AIDS, Tuberculosis and Malaria. In 1991, he was awarded the Australian Human Rights Medal. In 1998, he was named laureate of the UNESCO Prize for Human Rights Education. In 2010, he was named co-winner of the Gruber Justice Prize. And in 2011, he received the inaugural Australian Privacy Medal. So we're delighted and honoured to have Michael with us today. Mr Ross Abbs is a graduate of the University of Newcastle and was an associate to Michael Kirby in 2007-2008. And in 2010, he completed the Bachelor of Civil Law program at the University of Oxford. Currently works as a lecturer at the University of Sydney Law School, primarily teaching torts and criminal law. And I would also like to introduce Grace McCallum, President of the University of Newcastle Law Students Association, who will be asking questions for today's conversation with our guests. So over to you, Grace.
Okay, thank you, everyone. So the first question we have for you both is a bit of a broad one to start us off. But what is it like to work in the High Court, both as a judge and as an associate?
Well, as a judge, everything, first of all, I should acknowledge the Vice-Chancellor who's here and the Dean and the Pro-Vice-Chancellor, Professor Anderson, and other distinguished academics of the university. And I'd also like to acknowledge my former associate, Ross Abbs. Ross attended St Francis Xavier's High School here in Newcastle, which he told me, and I hadn't known this, was also the High School of Justice Michael McHugh, who was a judge of the High Court of Australia during the time that Ross Abbs and I were working in the High Court. And I acknowledge the other students who are here. And the point of today is to tell you, dream big, think big. The University of Newcastle is a great university, and I've been associated with it since the 1970s when I was Deputy Chancellor of the university. And all of you who are here from the region can be very proud of the university and its achievements. And Ross, well, he did get 2 university medals, so he was a most exceptional student, but he was proudly a Nova Crassian. And so I thought it would be more interesting, rather than having me making a long speech, to have Ross here today so we could exchange our memories of the time when we served together in the High Court of Australia. And that was, I think, in 2007-8, because I left the court in 2009. That was not because of the experience working with Ross. that was because an amendment of the Australian Constitution provided that High Court judges had to go, not as in the past when they chose to go, because we, like the Americans, had life tenure of the judges of the High Court, but that was changed in 1976, I think, and it was provided that we had to go at age 70, a very young age for me. And so I left the next year when I was about to turn 70, but Ross was there virtually towards the close of my time in the High Court of Australia. And we had the great pleasure and privilege of working together in the court. So I thought I'd start by saying how I got to know that I was going to join in the High Court. I was chairing a committee of the judges of the Court of Appeal in New South Wales, where I was the president. And I'd had a phone call that morning from a man in Canberra who said, "This is Smith. I'm from the Department of Prime Minister and Cabinet, and I want to know where you will be at 6 p.m. today." Now, I knew enough about the way Australian government worked to know this was a very, very important phone. So I didn't say, "Oh, well, I'll be chairing the committee and I can't interrupt that." I said, "I'll be chairing the committee, but if you want me, I will be here." And so at a certain hour after 6 p.m., my then associate in the Court of Appeal, Nick James, knocked on the door, and he said he had a post-it sticker, and I saw it being handed around and getting closer and closer to me, and it said, "Please ring the Federal Attorney General." And my brother, who was a solicitor, was sitting opposite, and he said, "I saw all the blood drain from your face, and I knew that I was on the brink of something new and different and important." And so I rang the Attorney General. He said, "I have the honour to invite you to accept appointment as a Justice of the High Court of Australia." And I said, "I have the honour to accept." I didn't ask, "Well, what, by the way, is the salary of the position? And what are the perquisites that they offer?" I simply said, "I accept." And so within days, I was in the process of being shifted from the Court of Appeal in New South Wales to the High Court of Australia in Canberra. So that's how I got the call. Now, Ross, I'd like you to remember, and we haven't talked about this, but do you remember I had the principle of always advertising for my associates? Justice Hayne once said to me, "You don't need to do that. That's a waste of time, because if they're any good, they'll know they've got to make an application." But I said, "I want to send a signal that this is an equal opportunity position, and therefore I want to see what the market bears." And so I advertised. Did you answer an advertisement, or how did it come about that we met? We must have met for an interview, and just tell us about that, Ross. I'd be interested to hear.
Quite unusual, this process that Michael ran, and I got an insight into it from the other side, because as your associate, it was my job to sort of superintend the interviews for the following year. But
which was the last year of associates.
yeah, so in any event, I sent off an application. And, there were 2 rounds of interviews, as I recall, and the first round involved an interview by video. And we're going back a long way here. There was no Zoom, no FaceTime. I actually was able to get the law school to tee up some video link facilities on campus so that I could meet the judge and speak to him for the first time.
Where was I? Where was I at the?
You must have been in Canberra or Sydney, I'm not sure.
Yeah.
Possibly Canberra, I think.
Maybe in Perth. I mean,
Maybe.
that's the beauty of video.
In any event, the microphone thing kind of brought back this memory, because the video link system went down midway through the interview. And Michael just froze at the other end. So I was sitting there for it wasn't quite that face, it was a stern face. The kind of face that suggested not impressed. So, you know, I'm meeting a High Court judge and yeah, looking to impress him, obviously, and I'm just sitting there for some time, feeling as though this is not going well. Anyway, it must have gone better than I thought, because there was then a second interview, I think, which might have taken place in person. And then, yeah.
It probably took place in person.
Yeah.
And do you remember what sort of thing I asked you? I tell you what was always important to me was not the medals and so on, because that was a given. Anybody who was applying had to be a good student. But I would always go to the end of the application where the student put the things they had done for others, things they'd done in their university life or activities they'd been in, or their interests. So do you remember what you had? You must have had something really impressive.
Wow. I don't remember specifically what would have been there, but I was involved in the Law Students Association, much like Grace here, yeah, and various other.
Were you a troublemaker to the Vice-Chancellor?
No comment on that. I wouldn't have mentioned it in my application if that was the case. But I mean, you ran so many of these interviews over the years. It's interesting to hear now that you know, that was what you were primarily interested in.
Well, it's natural, really, because the kids who are applying were all good achievers at university, and so I was looking for a discriminant, something that would distinguish an applicant, and I think your application did refer to your extremely good academic record. So I thought this is a bright cookie, and I should look at him very closely. Who was the other person who was chosen in that batch?
Joe Lennon.
Joe Lennon, and she was from the University of Technology, Sydney. So she was a very good and able person. Other things being equal, I always chose somebody from the non-sandstones, because the sandstones got pretty well looked after by most of the other judges. Would that be a fair comment?
Yes, absolutely.
And so I had another rule, and that was one male, one female. And that's not strictly equal opportunity, but it does mean over a period of 10 years or 20 years, you're going to get a good mix. And do you think that was a good idea to have? I did it partly to make sure that you, in a legal environment, before you went out into the big world, you had to work closely with a colleague who was of a different gender. And that Joe would have kept you on your toes, I think.
Yes, absolutely. So the way the system worked, I suppose, was that Michael always had 2 associates at any given time. And there was just a rolling arrangement whereby a new one came in every 6 months. So when I arrived, Jo was the old hand. And I seem to remember she was extremely stressed that week. She looked after me, but I don't know, you must have been making demands of her.
Surely not. Yeah, well, she was a very hard worker and you were a very hard worker. And I think it's fair to say that the job was a very hard-working job, wasn't it?
Yeah, absolutely.
Was
Well,
it?
I suppose we're circling back now to Grace's question about what it's like to work in the court. Did you want to talk about it from the
Yes.
judicial perspective? I'll give you back this in case.
Okay, well, in the court, in the High Court in Canberra, there are actually 3 courtrooms in the High Court. Court number 1 is the big one where tourists go, and it's a very grand court, and that is where the constitutional and other big legal cases are argued. So that's a very big court. Then there's courtroom number 2, which is the ordinary working court. That's on a different level in the court, and that's where most workaday appeals are heard. And then there was courtroom number 3, which is the practice court. So that is where you would argue cases to strike out a pleading or to get expedition in the hearing of an appeal or matters of that kind. And I would sit in the on the bench in strict order of seniority. So I started right down the end and I gradually worked my way up to closer to the centre, though for some reason I never got to the central seat. I sat there occasionally when I was acting Chief Justice, but that is reserved to the Chief Justice, and the associate sits behind and watches the case unfold. So you might now pick up the story, or you've taken me in, you've pushed the chair, I'm sitting down, and then what did you do after that, Ross?
Well, the associate's role is multifaceted, I guess. There are a few different things you have to do, and what you have to do depends to a certain extent on the personality of the judge and what he or she needs. But yeah, the court-based aspect of it, I suppose, does involve just sitting behind the judge whilst in court, maintaining a trolley of books that the parties have nominated as potentially wanting to refer to. When I say books, I mean primarily law reports, of course, like this one here. It was a wonderful opportunity, really, to see the courtroom from the perspective of a judge sitting behind the bench and watching very high caliber advocates, including the likes of Stephen Gagler, as he then was, arguing matters.
Musselbrook High School.
Yeah. So far as the court side of things was concerned, you were just there to assist the judge with things he or she needed. And not just books, I should say. There was Barocca, I think, typically on our trolley.
Yes. I don't want to give an impression that I had a hard night the night before. But I always gave myself a bit of a kick. Some people do it with coffee. I had a Barocca. And the court reporters said, we always knew you were sitting because suddenly at 10:05, after the court had started, there would be this sound of fizzing.
Yeah, well, that's the thing. It definitely wasn't a secret for that reason. The courtroom acoustics gave away the game there. But yeah, in court, that was the sum of it. We had to dress up in these quite ancient uniforms that the High Court had a repository of, and they're probably still the same. I don't know if they would have been updated or not.
No, I think they're still the same as they were, and some things never change. Though the High Court, by the time you came, was not wearing wigs. In the Court of Appeal, I used to wear a wig every day in the court, but that had been abolished before I came onto the court. I think Mary Gordon was the one who said, I've already got a hair and I don't need a wig. And so that was dropped. But you nominated a case that we worked on together. The many cases that we worked on was Dedera and the Road and Traffic Authority. And the barristers in that case were Brett Walker, SC, and David, who was it? I'll just have to look him up. Who was a QC. Jackson, yes, that's right. David Jackson. And they were two of the best barristers in the country. Did you notice something about what I was doing during the hearing? Because I learned something in the Court of Appeal that really affected the way I did my work as a judge. Did you notice that I was always drawing a T diagram of the arguments as they were coming out in order to see this is something I'd learned at high school, to see the main issues in the argument and then the sub-issues and going to the side the way I would resolve them. Justice Marnie in the Court of Appeal told me, we're not here to enjoy ourselves. We're here to work and to get ready for the product, which is the judgment in the case. And therefore, that was something I was always doing, scribbling away and writing away, keeping notes. But some of the justices just seemed to be enjoying themselves, which I was told was not what I was there for. But would you say you enjoyed the year, or was it just too busy and too stressful?
Oh, I absolutely enjoyed it. I mean, it was a fantastic opportunity.
What were the other associates like? Did you get on well with them? Were they in any way different in other chambers than in my chambers?
Yes, some different personalities involved, and I think that does reflect the fact that it is quite a personal role for the judge. Judges appoint people who presumably they're happy to have around for a year, and different judges are happy to have different people around.
Yes, I think some of the judges might have had people who were a bit more conservative than you were, and but it wasn't politically chosen. It was chosen on merit and on the assessment of how hard you would work and whether you would enjoy it. And if you enjoy it, make the year an enjoyable one also for me. It's a very personal interaction, isn't it?
Yeah, absolutely. And it was hard work, no doubt about that. Another thing variable between different judges, I think, in terms of what they expect their associates to do. Perhaps we should talk a bit about the judgment writing process as you saw it and how you tried to involve your associates in that.
Yes. Well, I would take my tree diagram and eventually I would dictate what I thought was the outline of an opinion. Different judges were different. There was one justice who always had a draft which had been prepared. He would come into court with a draft. In fairness, he would always make a lot of modifications and changes to it, but that was his way of making sure he didn't miss a point in the case. But in my case, I didn't have a draft, and basically I accepted the responsibility of writing, dictating, and then having typed up by Janet. Now tell everybody who Janet is from Newcastle, and she was a wonderful colleague.
Yeah, so Janet was your PA for many years. She went back to the Court of Appeal, didn't she?
I think so, when I finished, but I think she basically had enough. She started in the Court of Appeal, and then she didn't come to Canberra. She worked from Sydney, and but she was from Newcastle, and her daughter Donna was a lawyer in the either the legal aid or the prosecutor's office. I think prosecutor's office in Newcastle. So, and she was a real personality, wasn't she?
Yeah, oh, she was sort of the boss of Chambers, really.
Yeah.
I mean, you might have thought it was you, but I think.
No, I knew the pecking order. I knew that.
She was certainly the boss of the associates. I mean, Janet, was there for many years and had this parade of different associates come through, and she was a real character to have around.
She, mind you, she wasn't very favourable to the Queen. I had a portrait of the Queen in my chambers, and I would sometimes find there was a moustache on the portrait. And I said, really, Janet, this is not appropriate to Her Majesty. And but anyway, she was a fantastic typist, wasn't she? She would get through more than any other because I produced more than others. And so let us go to the case of Dedera, which I think I read it on the train coming up here to this morning. And what surprised me about it, to go back to a case of 2007-8, was how detailed it was, how detailed the facts were. It was a case about a young lad who jumped off a bridge in this area of Australia. It was between Kempsey and
Foster Tuncurry.
Yep.
Just up the coast.
And he jumped, and he hadn't allowed for the water level, which had fallen, and he didn't, he said, get a warning that there was a special peculiar danger of the drop in the water level. And the net result of this was he went head first into shallow water, and he ended up a partial paraplegic. And the question was, should the local council or should the Department of the Main Roads, or right now the RTA, have done something to prevent that happening? Would that have been what a reasonable council faced with this issue would have done, or at least put signs about the special danger of shallow water? And this was what the case was all about. And it had had a meandering course. The diver had won at first instance with the trial judge, Justice Dunford, a very experienced trial judge. And then the Department of Main Roads or Road Traffic Authority appealed to the Court of Appeal of New South Wales, and that court divided. Justice Handley dissented, but two of the judges of the Court of Appeal upheld the verdict, and then it came up to the High Court of Australia, and the issues in the case were the issue of the duty of care of the council or the RAID RTA, and the obligation to take steps to prevent this sort of accident happening, because the evidence was, and it was accepted by the trial judge, that young people at sometimes in the year, in the summer, would in large numbers be jumping off this bridge. And this was not something that happened rarely, it happened all the time, and young people were jumping. And the mistake of Mr. Dedera was he didn't just jump, in which event he probably, even with the shallowness of the water at that time, he probably would not have been injured, but he dived. And that was what caused the paraplegia. When he had emerged, he said he suddenly felt he didn't have any feeling in his legs, in his leg and in his lower body, and that was paraplegia. And so it came to the High Court. The High Court divided. And there was one other judge who would dismiss the appeal, and that was Chief Justice Gleeson. And three of the justices, who were the three who, I think it was Justice Gummow, Justice Callanan, and Justice Hayden, was it?
Might have to check the book.
I don't think it was Justice Hayden, because I don't think he'd been appointed at that time. But the three of them held that there was no duty of care, or if there was, the RTA had done what was required of providing warnings. And that was, yes, right up the back. You can't hear? Ah, right. Okay, thank you for asking. That was, now you teach DETRA, don't you, now at the University of Sydney Law School. So perhaps you can tell what your recollection, and was there a bitter confrontation in our chambers about the matter, or did you basically go along with what I was saying in the case? Just to answer honestly.
I agreed completely.
That's what I like.
It's interesting that you mentioned the meandering history of the matter, with the plaintiff succeeding at first and then ultimately the judgment being overturned in the High Court, because even though you were technically in dissent, as was often the case, so I like to think you were in the majority, because 9 judges involved, 5 of them actually agreed with your conclusion. I just didn't happen to be in the right court for their view to prevail. So it's an interesting case in that sense, I think, and it's one I often highlight to my students, is illustrating that some matters are just very finely balanced with a lot of scope for argument as to what the right outcome is.
Well, the first thing, I suppose, is the right approach. How do you approach it? Then how do you apply the principles of law? Because there was a question in the case, a so-called causation question, even if the counsel had made a clearer sign, would that have made any difference? Would a young boy of 14 years of age, who was in the spirit of life and didn't know about the danger, would he have been affected if there had been a clearer sign or a specific sign about the problem of shallow water, and not only a verbal sign, shallow water, but a signograph which could make a person think about that aspect. So there were questions within questions, weren't there? Mm.
Yeah, it's one of the key issues ended up being whether the signs that were in place on the bridge were adequate for the RTA to have discharged its responsibilities to look after people, essentially. And those signs were just basic no diving pictographs, I think, with nothing to indicate that the water was shallow, anything specific like that. And I mention this because I was talking to someone at morning tea about your championing of headings and subheadings in judgments, something that is pretty routine now, but was not traditionally.
Oh, look at that. They've got through page after page without a single heading.
Well,
it's a complete menace.
There was a passage in your judgment addressing this issue of the adequacy of the existing signs, and your subheading was "the signs were useless." It was straight to the point, I thought.
Yes. And all the other sides, subheadings were pretty good too. And also, I think a good thing about my reasons was I always started off by trying to say what this case is about, so people could then approach the case was about. And then with the associate, we would go through it. We would check that I'd covered all the points. And they were very complicated facts, weren't they? I mean, I'm amazed at how brilliant I was in those days that I could have mentioned all those. And you must have helped me very much on that case, because it was a matter of getting the facts right. If you got the facts right, you were on the way to getting the decision right. And that was usually the case.
Yeah, well, I mean, I guess circling back to the associate's role with respect to this kind of thing, in your chambers and in your practice, you had your associates proofread judgments, and that wasn't universally the case, I don't think, elsewhere in the High Court or elsewhere more generally. I think in some other instances, judges had their associates involved at an earlier stage when it came to assessing matters. That was certainly my impression. But this case, RTA debtor, was the first one handed to me for proofing when I started with the judge. So Joe Lennon, who I mentioned before, was giving me an induction, I suppose, and
Test of fire.
Thrust at me this draft judgment. And I think, you know, your priority was generally, when it came to proofing, having us think about how everything hung together and how well things were explained and that sort of thing. I don't remember necessarily suggesting a lot of substantive changes, because obviously what you came up with was right. But I do remember, you know, suggesting some fairly significant things in terms of presentation, which were sometimes adopted, sometimes not. But an interesting process of working out how to present these records, I guess, that are so significant for the shape of the law.
And do you say that in, see, I don't know what went on in the other chambers. Do you say that they didn't get their associate to go through every word in their draft? I suppose you could, if you're a Justice of the High Court, you might have the view, well, look, I know everything and therefore I don't need to have somebody going through. But if you read Dedder's case, which is in 234, Commonwealth Law Report 330, you'll see how complicated it is, how I mean, the basic issues were straightforward, and the obligation of a judge of the High Court is to keep their eye on the basic structure and the basic issues, and to try to get people to be convinced with how they think the problem should be resolved. But in preparation for that final decision, you've got to have somebody who is going to go through and say, you've forgotten this fact, or you haven't dealt with these facts, or there's a problem with your reasoning here because of this or that factual or statutory reason. So, but what you said about preparing for the examination of a case to see whether it was suitable to come up to the High Court, because in those days, unlike now, the court had a special leave hearing list, which was quite substantial. And I would get down to Canberra on the Sunday night or the Sunday and work through the cases that were on the special leave hearing that week. And say something about the special leave hearing, Ross. What was your observation of a special leave day? Because that was always, from the point of view of the barristers, who only had, I think, 20 minutes to put their argument, that was a very stressful day for the barristers, but it was also very stressful for the judges, because they had to reach a decision very quickly, which was effectively the end of the road for most of the applicants. And they had to give short reasons at the end, which encapsulated the essence of it. How did you observe that? Did you think that was an interesting process, or did you think it was a satisfactory process? Because now it's basically all done on the papers, but which makes it more efficient. But open justice is something which, in some people's mind, is an important aspect of the role of judges.
Yeah, I mean, it divided focused advocacy, didn't it? Because there was a strict 20-minute time limit on speaking to the court, putting submissions. And at the end of 20 minutes, a red light would be switched on to tell the advocate their time was up. And actually, occasionally, as an associate, I had control of the red light, which felt quite powerful. A rotating task shared between the different chambers. But yeah, they were always fascinating, especially these days, because the variety of matters that would come up. There's inevitably a lot of interesting stuff to consider, but it did have to be dealt with so quickly. And I certainly didn't envy your task of having to make a call that would often sort of bring things to a conclusion in respect of a legal dispute that was clearly controversial and that people were invested enough in to try and make their way to the High Court of Australia.
I've always found that it's interesting to think that although I disagreed often in the resolution of cases, and therefore a question is posed, what was the criterion by which I was disagreeing with other very experienced and learned judges? But on special leaves, there wasn't all that much disagreement. The judges seemed to know what was a case that was suitable to come up to the High Court. They may disagree with how it was going to be resolved, but they could agree, and overwhelmingly did. I think in my time, there were only 2 cases of special leaves where I dissented from. One was Muir and the Queen, which was about whether the prisoner who was in Goulburn jail should, like other litigants, have the opportunity of speaking to us by a video link in order to express their argument. I was in favour of that. They were prisoners, but they still were citizens and individuals, and they shouldn't be discriminated against if they couldn't afford or didn't want a barrister. But if they didn't have a barrister, they would not be given an oral time unless the court made a special order for the prison officers to make a barrister available to them. They couldn't do it by AVR, which is now, I don't think, I'm not sure whether prisoners get the chance now, but they certainly didn't get it in my time. That went off to a committee of the United Nations in Geneva, and they supported my view, but that wasn't a fat lot of good for the prisoner involved. But did you feel that the other judges, would you agree with me that by and large, though there were disagreements, everybody was studiously courteous to each other? Or do you feel there were occasions where there was a bit of a bristle in the atmosphere? Speak honestly now.
Occasionally there was a little bit of a bristle, I think, but there were also meetings that I wasn't invited to, so it's a bit hard to know sometimes how heated the disagreements might have been in respect of particular matters. You've sometimes got a sense of it.
You're talking about the meetings of the judges outside the courtroom when the case had been argued and you had to have your preliminary discussion about how you were thinking of voting in the case. And that is a critical moment. And that would, it's true, be sometimes stressful or even occasionally unpleasant. But that's simply because everybody's taking their job very seriously and they want to say their point of view, and they are obviously very experienced and they think they've got it right and that I or anybody else who disagrees have got it wrong. But so it's true that there were disagreements, and sometimes when that arose during a discussion in the week after the High Court sitting, because we had, you remember, the link by audio-visual link to the chambers in Sydney and Melbourne and Brisbane. We would have the link and have a discussion by that link a week after. It's a bit like Parliament, you know, you go down for 2 weeks and you have the cases of 2 weeks, then you go to your outlying office, but then we would have these links. And sometimes I would say, there it is. And everyone would look at me and I'd say, the San Andreas fault has emerged. This is the fault that is the fault line in the case where we're having a different point of view. And that was often because of values, different values in the law. But I think on the whole, everybody was pretty courteous. We used to have a chambers lunch every sitting, I think. Is that right? Just about every sitting. And we would go to a dinner in Kingston. There was one great big slap-up dinner when all the associates took all the justices. But in our chambers, we would have a dinner in Canberra, and that was sort of a reward, but maybe it wasn't such a reward, it was just a nuisance, interfering your social life.
No, not at all. It was always a nice part of Canberra sittings. And I guess just to contextualise this, as has been mentioned, you were in Sydney a lot of the time and just in Canberra for sittings. One of the associates would stay with you in Sydney and travel to Canberra with you. The other would be in Canberra full time, doing more of the proofing work and that kind of thing. You know, when there was some peace and quiet and court was not happening. So yeah, for the first half of my tenure, I was in Sydney and would travel down to Canberra. And for the second half, I was based in Canberra. But yeah, when everyone was in Canberra, it was good. And I mean, I like Canberra. Something
I like Canberra. And Johan, my partner, liked Canberra very much. So we were, whereas most of them, their chambers faced the airport. That was a big mistake of the architect because the airport was where they wanted to be on the way out. But Canberra, you know, the star canopy in Canberra is like nothing else in Australia. They don't have any industry, so there's no smog or anything, and you get the most wonderful stars at night. And did you used to walk in Canberra?
Yeah.
Yeah.
As did you, I think.
Yes, I did. We did. We would walk around Canberra, but we've taken a long time. You might have some other questions.
Oh, we're going to wrap up with one more question. The last one, yeah. So the last question we had for you was, what is the role of legal professionals in modern day Australia?
Well, naturally, I think the role of professionals is to serve the judges and help in the administration of justice, help in the outcome of cases, work very hard because the work does have an impact, and not all cases come to court. Most cases don't come to court, but in that relatively small number that do come to court, it's very important that you work your guts out, actually, and that you're prepared to take a lot of time, because by that stage you're making decisions that affect the law of the country, and that's a very important role to play. And that's where we would see David Jackson and Brett Walker, two absolutely top barristers, and that they have a very important role in what the court product is.
Look, it's a broad question, and legal professionals do all kinds of different things, I suppose. But I guess, in a sense, what is important to all of them is maintenance of a system that is respectable and workable, and one that I guess contributes to the well-being of our country, because we see elsewhere that there are, I suppose, issues in terms of the respect accorded to courts, respect accorded to the law more generally. Things can break down pretty quickly. So I guess legal professionals have a frontline role in that regard. Aside from all of the other more specific responsibilities they could be seen as having.
And did you feel you had a good law course at the University of Newcastle that prepared you?
Absolutely.
And at school at St Francis Xavier, did you actually learn legal studies or not?
I didn't do legal studies, no.
This was you were concentrating on philosophy and ancient history, but you ultimately came into the law. And do you feel that that is something that young people in the audience today can aspire to? And it might be in the district court, or might be in the Court of Appeal, might be in the High Court, but would you recommend it to them?
Yes, and look, the pathways are there. Sometimes that can be hard to see, but particularly for school students, and it's something they're interested in. And it does involve hard work, as Michael emphasised before. It is a very worthwhile thing to pursue, I think.
Right, well, that's it. We've answered all your questions.
And thank you on behalf of the School of Law and Justice and the University of Newcastle, Michael and Ross, thank you for your presentation today. It's been really wonderful to have these insights into what it's like to work in the High Court of Australia. And thank you, Grace, for sharing that for us today. And we have a small token of appreciation for both Michael and Ross today. Thank you, Michael.
Thank you very much. I wonder what this is.
Thank you, Michael, and for Ross. Thank you, Ross. Thank you. And if I could just ask you to remain seated for a few moments while the official party leaves, and then thank you all for coming today, and we look forward to seeing you again at a future event. Thank you.